Well, we made it anyways. We made it anyways, John. We appreciate you dealing with the technical difficulties.
Well, I jokingly have said one time that when I started practicing law, the biggest technological challenge I had was making sure all 7 pieces of carbon paper faced the same direction. And when I made the comment,
legal paths.
Somebody came up afterwards and said, John, Mr. Howe, I didn't want to embarrass myself, but what's carbon paper? So tells you where we are, kids.
I know. Well, we're at 1 o'clock, John, so it's time to start. Good afternoon, everyone. Before we begin, a few words about Cadre. We're sponsoring this series of conversations with industry experts. Cadre is an online marketplace, and our goal is entirely to connect event industry freelancers with people looking to hire them. For people looking to hire them, it's largely planning organizations, and we try to make the contracting, finding, paying, all the administrative hassles of working with freelancers. We try to put all that in a nice, simple box that we call Cadre, and we give you a compliant way to hire them. For all the freelancers out there, whether you're a travel director, contract meeting planner, event staff, audiovisual staff, we're trying to get you work. Right? So we're asking both parties to sign up today in Cadre, creating your accounts free on both ends. The only charge is a $12.50 third-party background check that we're covering half the cost for, which brings it down to $12.50 for freelancers. And finally, we'd like to welcome Meeting Jobs as a new Cadre company. Meeting Jobs as the top premier industry online permanent placement job board. And we've brought Dawn Penfold on board, and she does a lot of pre-qualifications of resumes and retained searches. So if we can ever help you contracting staff, finding staff, or getting a job, please check out both of our websites at hirecadre.com and meetingjobs.com. Jonathan Howe needs no introduction here today, although I will give him a brief one. He is the founding partner of Howe and Hutton law firm here in Chicago. Most of you probably know John. He is well respected in our industry. He's a super smart guy, a superb attorney, went to Northwestern, Duke, and he's largely built his practice on developing a niche in the meetings and events and association marketplaces, those industries. And he's just the guy you go to if you want to know and what you have to deal with legal issues in those industries. So, Counselor, it's great to have you here today.
Thank you very much, Todd, and I thank you for the very kind introduction. Almost word for word what I wrote, but that's good.
I know. So John, we have a meeting today, a seminar today to talk about the questions people don't ask you that they probably should, right? So all the things that, or at least the things that smart companies are asking or smart clients are asking that maybe not everybody is, right? I've got a lot of questions that people submitted ahead of time, and they deal with force majeure and testing of COVID, and you've been talking about that a lot, right? So I'm going to give you a little bit of time at the end of this just to give a broad brush answer to kind of those two topics. But let's kind of come back to the main point here today. What are the risks, what are the things that people aren't asking you about that they should in the meetings and events industry right now?
Well, let me put it this way, Todd. It's not the questions that are not asked. It's the uncertainty that we're facing right now. So we have lots of questions like, what's going to happen tomorrow? I don't know what's going to happen tomorrow. But what we're doing and what we should be doing is making and anticipating to the best of our ability is, what is it that I have to do to pull off the successful event, regardless of whether it's a pandemic, a hurricane, whether it's a normal type of day going on. We have certain things that we have to plan on in contingencies. And so many people just have a plan A and they don't have the plan B. Mm-hmm. So they need to begin to think about seriously, as we've learned from the pandemic. We've been out of sorts for a year, a little better part of a year. And it's now, what are we doing? We've heard the term, the new norm. Well, I don't believe in the new norm. It's a new reality. We're looking at things in an entirely different way, or should be
Mhm.
looking at things in an entirely different way than we ever did before. And that's a key element that so often is overlooked, is that, well, I can't wait to get back and just make minor adjustments. We're making major adjustments. We're throwing out the old playbook. We're coming forward with a new playbook to look at and how we anticipate what we do, how we plan for, how we assure the publics that we come in contact with that their safety, their health, their best interests are being attended to, or at least paid attention to.
And so what are some of those new things in the playbook that clients, planners, on-site staff should be thinking about that weren't in the old playbook? What are the additions?
Let's take a look at one thing that I think is so important. The one thing that a lot of people learned is they cannot wait until the last minute to make a decision, because the last minute under force majeure is the day your event is supposed to take place. What we have found is that really the last minute is maybe 190 days, maybe a year in advance of that, so that all of the things that need to happen leading up to the time for the event have to be able to take place. So if you got, let's say you're dealing with a situation where you need to have certain specialists, you're going to have to get those specialists on board early. You're going to have to make sure they can travel. For example, in some situations, you may be having people coming to a session or to a program that may be from outside the United States. You're going to be forced into thinking about, when is it that I have to know what it is? So what we do is we base our decisions upon what we know the day we have to make the decision, not what we anticipate is going to be taking place on the day of the event. And so if we have a force majeure 120 days out, that may lead you to have some kind of thought that maybe I'm not going to be able to pull this puppy together because the force majeure, which is going on right now, is impeding my ability for the next month in anticipation of my event to get my ducks in a row for purposes of pulling it off. That's one thing. The other thing is looking at your contracts. We're seeing a whole new array of what's taking place in contracts. It's not static, and in all aspects of everything we do now is, please read the contract. One of the biggest problems that I've had with clients is I'll ask them, well, you've read the contract. Well, yeah. I looked at the dates, the rate in the book or the block. And regardless of what kind of contract it is, I know everybody on this Zoom call has read the terms and conditions of participating in a Zoom call. In addition to knowing exactly what their Facebook agreement states. No, we don't. We don't read it. We don't pay attention to it. But even though we don't pay attention to it, we're bound by it. My definition, simple definition of a contract, it's a self-inflicted wound. And what you do in a contract, you're going to have to honor, and we hope the other side is going to honor it to meet the requirements that we're dealing with. So that's sort of the type of grounds we're dealing with today. We've been dealing with these grounds overall almost all of the time, but it's become even more important today than it had been in the past.
So I'd imagine many professionals that saw contract after contract after contract just got used to signing the contracts, right? And if nothing goes wrong, that's great, right? Until something goes wrong, and it did. So then everyone goes scurrying to go look and read the contract, right? And so in terms of risk in going to an attorney, because we're all not attorneys and we look at those contracts, two questions. When someone gets a contract, you probably read it word for word, but for us, the layman, are there certain areas like hotspots of all that language that we should really check, right? And so much so that we go, I got to check these, because if I don't check these and I don't understand them, I do need to go to an attorney. Like, what triggers us to go to you? Because that language is so nuanced and new. They'd always don't want to go to you for everything, but when should they?
Well, that's a good question. I think what we've learned is that nuance sort of prevailed in the last 13, 14 months. as to what exactly is a force majeure. I kiddingly say, beware of lawyers wearing Latin phrases, but force majeure is French, so I guess I can talk about it. Bottom line here is that the lawyer is not there to make business decisions. The lawyer is there to advise you on the legal aspect of the business decisions that you have made. I might share a word or two with some of my clients as to have you really considered what the rate structure is relative to what you're doing? I mean, we've looked at a lot of contracts from that particular venue. You're either getting a real super duper bargain, or there's something wrong with the calculation, or you're paying too much. So, but we don't necessarily get into the business decision making. And when we get down to some of the contract terms, we'll suggest to a client, you really need to get rid of this clause. You need to substitute this clause. You need to make changes, or you really should take this clause. This is really good for you. We'll help you understand the legal aspect of it. Mm-hmm. But you put your finger right on it. If you have a doubt, if you have a question, rather than trying to think about or try to figure it out perhaps yourself, call a lawyer, and more importantly, call a lawyer who knows something about the business that you're in. And I think that becomes a key. I kiddingly say to a lot of my friends who are lawyers who get in the hospitality industry as dirt lawyers. And by dirt lawyers, I mean they were there for the development of the construction and opening of the hotel. And now suddenly they're involved in the transactional aspect of what they're doing. And I like to remind, especially in some situations with convention centers, I just want to use it. I don't want to buy it. And so many of these contracts are based upon terms that might indicate you're about ready to buy the bloody place.
How much? I'm sure every hotel or every venue, every property is a little different, especially when you're dealing with different people. But how much of it is negotiable? Like how much? Sometimes you get a contract. I'm not going to be able to negotiate this contract with Verizon, my cell phone company. It's take it or leave it, right? So, what is the legal landscape now in terms of who's got the power and who doesn't, and how much of that can be negotiated?
Well, the old story is if you don't ask, you don't get.
Uh-huh.
So basically, having said that, almost everything is negotiable, or at least you can put it on the table. If the person comes back, one of my favorite cliches in this business is, well, it's against our policy to make any changes in this. To which my response is, well, it's against my client's policy to accept anything like this. Yeah. So can we get down and see if we can make a deal?
Yeah.
And so you get over, so many times we say something is non-negotiable. Very few things are non-negotiable. What would be non-negotiable if I'm a hotel and the dates that you want are already filled with another customer? That's non-negotiable. I can't give you the space. It's gone. So that's a non-negotiable thing. But it might be that before or after those particular dates, if you're well ready to make some wiggle room and make some deals, you could probably work into a schedule. Maybe not the ideal dates for you, but you can work around it. Or, as I have seen on many occasions, that you may have somebody may have a 24-hour hold on a particular room, and all they're doing is really using it for a dinner. That doesn't mean it was occupied in the morning for breakout sessions and so on. So I think a lot of times it's being able to have the flexibility and ask why isn't it available? We've had a lot of situations where the hotel will get back to a person and say, we're sold out. And what they say is they're sold out on one of the 4 days that person wants to be there. So the question is, when you say you're sold out, does that mean you're sold out for all 4 days, or you're just sold out for 1 day or 2 days out of that? Can I make an accommodation on that? So a lot of times it's pursuing and asking a question. So much of this business is we're afraid to ask questions, and that's where we get into trouble. If you don't know, or you want to find out more as to why it's not available, what the terms really are, and what is the most unsatisfactory answer you get back is the other side, which has presented the clause to you or the terms, says, well, I don't know either. bingo, you've got a real issue and a problem. But I tell you, it happens so many times. One of the biggest complaints that we hear from planners and other people as well is when I ask the salesperson a question about what this means, they say they don't know. And that's really depressing. So good service and background and training to people really becomes important. And being able to, now, in a lot of situations, they may not know. And so the right answer there is, I don't know, but I'll find out for you right away.
So I want to touch a little bit on insurance. I know you're not in insurance, but you're into mitigating risk for clients, right? And insurance is into mitigating risk for clients. And so we're getting some questions about, they probably ask you too, do I need to do anything with my professional liability policies or my general liability policies? Do you know of any changes that this new world has brought us that you're recommending to clients gets rolled into kind of their professional package of insurances?
Well, I think we've seen over the last few months, last year and a half or so, that we're doing a lot more virtual meetings, aren't we?
Mm-hmm.
And we may be charging people for those virtual meetings.
Mm-hmm.
Well, what happens if, like what we sort of quickly experienced here, a technical difficulty that prevents people from either being able to participate in that meeting or hear the speaker they want to hear or whatever, and you're charging money for it. There is now insurance that covers for the electronic communication of a meeting materials that will protect you from liability overall. But read the policies very carefully, as we have seen with the COVID situation. I have seen both really fantastic stories come out of people who did buy insurance and people who bought insurance but didn't read what they were being covered for, which makes a difference too. Insurance, like contracts, it's a contract with you. And insurance is the granddaddy of all risk management. And with insurance, what you're saying is, I can tolerate just so much risk. Beyond that, I need to be insured. I got to have somebody else help me in doing that. And what is insurance? It's basically sharing risk with other policyholders.
Yeah. Okay. All right. I want to wrap around. We have about 10 minutes left. I want to wrap back to kind of the preponderance of questions that we got. And they revolve around basically two things. You touched on force majeure a little bit. So we'll come back to that one second. A lot of people have questions about the date. You mentioned the date that it becomes effective or use certain terminology. I think people want to understand that just a little bit more. But let's go to the first issue of this general issue of, and you've mentioned this many times on other things. So just a broad brush discussion. We can't get into individual specifics of COVID liability, testing, liability if someone gets it on site, all this kind of stuff, right? HIPAA law. Now, I don't even know if there's a question in there, John, right? But what's the one over the world kind of advice you give to someone about that nebulous area?
Well, that's a program in itself. But
Yes.
Real quickly, Todd, I would say the things you want to do is with the venue you're going to be using, where people are going to be congregating, the hotel where people are going to be staying, you want to know what their protocols are. What are they doing to make people safe, have a feeling of comfort and safety overall as they're there? And why should they come, and what have you done? We have a duty of care that's placed on, but we're not guarantors. We're not saying I've done everything possible and therefore I guarantee 100% that you're not going to get sick. I can more do that than guarantee you're not going to trip and fall or you're going to sneeze in 5 minutes. That's the kind of thing we got to avoid. But for example, this program I'm at here in Kentucky right now, before we even got here, they required within 72 hours of people coming that if you were not fully vaccinated, that meant you had your last shot in 14 days or 10 days had elapsed since you had it. You had to have a certificate from a testing lab that you were COVID-free or came back negative. Additionally, when you got here, you were asked a bevy of questions relative to, are you sick? Do you agree with the rules of the place? You'll maintain social distancing. You will wear a face mask at all times when you're not either eating or drinking. That you will cooperate with any needs that we have. You'll maintain social distancing and so on. The room set up for breakfast this morning was a table of what normally would handle 6. It was cut in 4 quarters, not 6 quarters. So you had 4 people at that table. You've had a temperature check as you came into the meeting. And then on your name tag, if you passed all those little deals, you got a little sticker color coded for the particular date as to you were okay to come and go. So I think those are things now that we're going to see. I think that it's the safety and health that's there, what you're doing. Some people may look at it as an imposition. A lot of people are going to look at it, if you don't do it, you're really endangering their health. So I think the key element that I found with this particular group and conference was everybody knew in advance what they were getting into. And they were asked before they went out to get on the airplane to affirm that they understood and that they
smart
what was going to be done. So from the duty of care, that's 100% of duty of care. Now, no guarantor that you're not going to get COVID, but we've done all we think we can do reasonably, meeting our responsibilities.
And they can, a lot of people are saying, can I do all that, right? Can I do all that? Now, they can do all that because it's a private event that's opt-in, right? And so the answer kind of is, yeah, right? I'm putting words in your mouth, John, but they can do all that because no one's forcing the attendee to come. Now, the attendees can certainly opt out of all that, right? But is that the general idea around why people can put all that out there?
Well, yeah, it is. But let me mention one other thing they have was this is a little RSFID radio identification that we go so that if we come in contact and they discover later that somebody we came in contact with has COVID, they can alert me, not telling me who it was, but by virtue of the point of contact, we have it. You mentioned HIPAA rules, and so that's another safeguard that's there. And again, being cautious and meeting. Now, to your specific question, if I am holding an event and I ask you to register for my event, and send in the fee, or you agree to it, or you do as they did here, as a condition of being able to attend, you had to agree to these particular conditions. You had to agree to social distance and so on and so forth, and to be honest in your responses. And if you say, well, hell no, I'm not going to put a face mask on, well, then don't think about coming to our program. We're not going to let you in. And you have the right to enforce your rules. But one thing too is when we get down into enforcement, I know that at some trade shows, they have what they call safety concierges who are going around and basically say, excuse me, sir, you don't have your face mask on.
Safety mask. Yeah.
And so again, sort of another kind of new opportunity. I would think that you're probably at Cadre getting some requests for people who have been trained in the protocols and can help and assist clients in being able to meet those requirements.
Okay, let's wrap around to the last topic and kind of get more specific on force majeure, specifically as to the date that you mentioned, like the technicality of that date, I guess.
Well, what I call it the drop dead date. What's the last date I have before I have to make a decision as a go or no go? Okay. And that may depend, but I think that's something we need to build into the contract. And we're seeing that with a lot of the properties that we've been doing business with, and we make this recommendation to the client, that the properties are willing to do it. Now, that's now, and properties are hungry for business. They want to get back on. Yep. Where hotels are filling up is certainly not from the convention or trade show business. It's coming from the free independent traveler, the pent-up tourist who wants to go to Disney World, get out of Dodge, do a whole lot of things. So that's there. But let me make one distinction. Force majeure is a word of art, legal meaning. But what that requires is that something prevents performance over which man, woman, or child had no control, that makes performance impossible or illegal. What we want also is to have a list of things which would allow us either to renegotiate the contract or postpone it or whatever, or to cancel outright based upon if such and such happens, we reserve the right to get out. For example, we have in most hotel contracts, we'll have a provision that if the hotel goes through a flag change, if it goes from brand A to brand B or brand X, that we reserve the right to get out. Or if there's a change in ownership, or if there is a drop in the number of stars. If it's a 5-star hotel, when I book it, I expect it to be a 5-star hotel when it comes time for performance. And if it's not, I reserve the right to get up. So we have a whole list of things outside of force majeure, which allow us either to replace or renew or to go forward or to renegotiate or to cancel if that event happens or doesn't happen as we set it forth. So we have our list of
very interesting. So you're saying try to take those risks that you could possibly see and don't let them fall in under force majeure.
Get them out of force majeure.
Stipulate those up front and reserve those so that you don't even have to deal with, is this force majeure or not? We've
Correct.
said that if this happens, in the event that event A happens or B happens or C happens, then we have the right to.
We're gone. We're history. And absolutely. I mean, that's where force majeure got so muddled up.
Yep.
That it became impossible. Another classic example is state what the purpose of your meeting is and why. If you're doing a product introduction and all of a sudden that product is not available, that's not a force majeure.
No.
That's not going to be something. But if you have in the contract, I can get out of the contract with my product, let's say in pharmaceutical in particular. If the FDA has not approved my drug by the time this meeting is going to take place, I reserve the right to get out with liability or to reestablish the time frame for when it is going to be held. And that makes a lot of sense from both sides.
Yeah, it does. Yeah, it does. That's a great point. Okay. Well, we're hitting hard on our deadline here at 1:30 even. John, we have a lot of specific questions, right? You can't deal with specific questions in a broad group setting like this. Counselor, how do people contact you if they want to work with you and talk through some of these things?
My non-advertisement advertisement is, my email is J as in John, T as in Tom, H as in Howe, at howehutton.com. That's HOWEHUTTON.com. JTH at howehutton.com. All one word, all lowercase. Phone number, office 312-263-3001. 312-263-3001.
Super. We're putting that into the chat right now. Both of them are up there, both the email address and John's direct line. And true to form, we're going to give you back your afternoon. John, you've been super. We really appreciate you coming here. You've been on twice. I think you hold the record for the most attendees, and we may bring you back a third time if you're open to it.
Well, I hope we maintain that record, Todd. And make it better.
We will. Thanks so much, John.
Thank you.
Thanks, everybody. Have a good day.
Stay well.
We will.